Hello everyone. So today we are going to discuss the previous year questions regarding the CBI, APP and the PPP exams. Okay. So there are certain criteria you have to go for the eligibility terms given in the advertisements. Today the main concern of this particular session is regarding the discussion on the previous year questions. There are 6 parts. Okay. First part is consisting of 20 questions. Today we are going to focus on the questions of Indian Evidence Act as well as IPC and the Indian Constitution. So moving ahead, this is our part 1. First of all, you all should know that the paper consists of 300 questions. The paper consists of 120 questions. Moving ahead, pages here. Okay. So here, this CBI, APP and the PPP exam is for the people, especially the PPP exam is for the people who have a 7 years old experience in the field of law as an practicing advocate, and for the freshers we have the vacancy of APP. So you can see the previous videos regarding this. Right now the main concern is discussing about the previous year questions. So coming on to the question part, the first question is which among the following provision of the Constitution of India to requires a guardian to provide opportunity for the education to his wards between the age of 6 to 14 years. So this is the question paper. The question is regarding the Constitution. Okay. So the thing that needs to be focused here is the guardian's duty, and we have the concept of fundamental duty under section article 51 of the Constitution. Okay, article 51 capital A is talking about the fundamental duties. There are 11 duties, out of which the 11th duty is added in this article. Okay, this article is basically talking about that it is the duty of the guardian to send their children for the education purpose to the school, the infrastructure which is being created by the government, as the government is obligatory under article 21 of A capital A, which is talking about the fundamental right regarding the education. It was added, you can add in that it was added by the 86th Amendment Act. Okay, so this is 86th Amendment Act. It came in the year 2002, but the date of enforcement is 2010. Okay, after 8 years it got enforced. You can also get the date. Now the second part is this section 24, section 51, article 51A. We have 4 options. Out of this, the most appropriate is article 51 because they have mentioned the term guardian. Okay, now moving ahead. Now the second question is talking about considering the following statement. Since I have said that the question consists of Indian Constitution, IPC and the Indian Evidence Act, first 20 questions are focusing on these areas. So you can have your bare act also. Now the question is, people of India have liberty to faith and worship. We are well aware of this fact that we have the fundamental freedoms, and under that we have the liberty of thought, expression, belief, faith and worship. So the first statement is correct, because the question they are asking is which of the following statement is correct. Now the second statement is morality cannot override the freedom of faith and worship. But if we'll go to article 25, we will find that there is a restriction on the basis of morality, health, morality. Okay, there is a restriction. So as far as article 25 is concerned, the second point is wrong. Okay, so the correct answer is only one. So we'll click on the first. So the right option is A. Now coming on to the third question. Third question is, considering the following statement with regard to the fundamental right to freedom of religion. We have the freedom of religion under the chapter of fundamental rights, that is part 3, and among those we have article 25 to 28, which is specifically talking about the freedom of religion. So if we'll focus on article 28, you will find that there is mentioned that no religious instruction shall be provided in any educational institute wholly maintained out of state fund. Okay, so this is one. Second is, religious instruction may be provided in any educational institution established by any trust, which requires that the religious instruction shall be imparted in that institution, even through that institution, even though that institution is administered by the state. This is the second option. And the third option is, no teachers or students attending. This is right, this is right. Now the third part is, no teacher or student attending any educational institution recognized by the state shall be compelled to attend any religious workshop at any as they may be conducted. So we cannot be compelled to attend any religious workshop. Okay, so the third option is basically not correct. So they are asking which two are correct. So the answer is, one is correct, 2 is correct, and 3 is correct. So the answer is C. Now moving ahead. The question number 4 is talking, considering the following statements, only question of law can be the subject matter of litigation before the Supreme Court under Article 131 of the Constitution. So here, when you will refer Article 131, you will find that the Supreme Court has original jurisdiction. So under original jurisdiction, you will find that on the question of law as well as on the question of fact, they can exercise the original jurisdiction power. So the first statement is correct. Now the second statement is, any question involving the legal right of the state against the government of India can be decided only by the Supreme Court. So the Supreme Court has a power to decide, they have the original jurisdiction under certain matters. So if the certain matters are concerned, so if the dispute is between the state and the state, between the center and the state, so they exercises power. So the first part is talking about law and fact, but they have mentioned that subject to the question of law only they have mentioned, they have not mentioned fact. So the first point is wrong, the second point or the second option is right, and they're asking which of the following above given is correct. So in that we have the B option correct here. Now question 5. Question number 5 is basically talking about, the quorum to constitute a meeting of the House of the People is 1/10 to the total membership of that house. So the Lok Sabha, the quorum for the Lok Sabha is basically 1/10. Yeah, this is the right statement. If at any time during the meeting of the House of the People there is no quorum, the speaker has no option but to suspend the meeting. So no, this is not right. They have the option to suspend the meeting or adjourn. They have both the options. They can either suspend the meeting or they can adjourn the meeting. For this quorum part, you can see Article 100. For the second thing, you can write that there is a adjourn not given in the option. So the second option is not correct. Now coming on to the third point, the chairman of the council of the state has only a casting vote in cases of equality of votes. Yes, this is correct. So the question is, select the correct answer. So one is correct, third is correct. So the correct option is B. Now coming on to question number 6. Question number 6 is talking about, again, the constitutional question. The member of the committee of a parliament on official language. For this you can refer article 344, which is talking about the official committee on the language. The member of the committee of the parliament on official languages are elected by the members of the House of the People and the Council of States in accordance with the system of proportional representation by means of transferable vote. So whether this is the correct option or not, let's see. Yes, this is the correct option. If you can refer article 344, you will find this provision. Now just remember one thing, under article 344 you can find that this committee is consisting of Lok Sabha and Rajya Sabha members, out of which out of 30 members 20 are to be from the Lok Sabha and 10 are to be from the Rajya Sabha. So out of 30 members, this is the ratio, 20:10, okay, from the Lok Sabha and the Rajya Sabha. Now coming on to the second option, the chairman and the member of the Official Language Commission are appointed by the President of India. Yes, this is also a correct option. They are appointed by the President of India. The third option is the representatives of every state in the Council of States are elected by the elected members of Legislative Assembly. Yes, this is also right. Are elected by the elected members of the Legislative Assembly of the state in accordance with the system of proportional representation by means of single transferable vote. So the answer, option third, is also correct. So now here the answer is D. The answer is D in question number 6. Now we are going ahead with question number 7. Let's see what it is. Question number 7. Question number 7 is, under the Constitution of India, for the Union Territory of Puducherry, the Parliament may by law create which of the following: an elected or partly elected and partly nominated body to function as legislature. Yes, you can find it under Article 239, capital A. You will find this provision. So please do refer Article 239, capital A, which is talking about the administration of UTs. Okay, so this is the right option. Now the second point, that is the Council of Ministers. Yes, the Parliament has a power to appoint the Council of Ministers for the Union Territory of Puducherry. Okay, so both the options are correct. So here the correct answer is answer C. Okay, I hope you have written all these articles which are important, and do refer in the Bear Act. Moving ahead with question number 8. Question number 8 is talking about which of the following is are not considered to be an amendment of the Constitution of India. Okay, इनमें से amendment कौन सा नहीं है, तो इनको amendment नहीं माना जाता. Law made by the Parliament by exercising power under Article 2 and 3. तो अगर law जो है Parliament ने बनाया है कि आप अपनी power को exercise कर सकते हैं under 2 and 3, तो this is basically not an amendment. Okay, law made by Parliament with regard to union territories referred to under Article 239. Again, this is not an amendment. So they are asking इनमें से कौन सा correct नहीं है, which of the following are not considered to be amendment. So both the options are not considered to be amendments, so both are correct. Okay, so we'll mark C as an answer. Now coming on to question number 9. Again, the question from the Constitution. Considering the following statement in respect of proceedings in the Parliament, the validity of any proceeding in the Parliament can be called in question on the ground of irregularity of procedure. तो क्या ये सही है कि क्वेश्चन किया जा सकता है पार्लियामेंट्री प्रोसीडिंग्स को बिफोर द कोर्ट? तो वी ऑल नो अबाउट दिस दैट दे हैव सर्टेन पार्लियामेंट्री प्रिविलेजेस, और उसमें ये भी है कि उनकी प्रोसीडिंग्स को कोर्ट में नहीं किया जा सकता है डिस्कस. So you can refer Article 122 of the Constitution. Okay, for this purpose, so cannot be questioned. Okay, this is one. Now An officer of the parliament having the power to maintain order in the parliament shall be subjected to the jurisdiction of the Supreme Court. So here shall not be subjected. Okay, shall not be, तो यहाँ पे आप not लिख सकते हैं या इसको ऐसे समझ सकते हैं that shall not be subjected to the jurisdiction of the Supreme Court in respect of the exercising of the power for that purpose. So here again you can refer Article 122 for this purpose. So both are wrong. So the right answer is neither A nor B, or neither 1 nor 2. So the right answer is basically D. Now we need to go to question number 10. Question number 10 is basically the total number of ministers in the state cannot exceed 15%. Okay, this is the law of the total number of members of the legislative assembly of the state concerned, and there cannot be less than 12 ministers. Okay, so suppose the overall strength is 100. So out of 100, the ministers cannot be more than 15%. So we can have 15 ministers. Okay, and cannot be less than 12. So we can say that this is something which is mentioned under Article 164. You can refer Article 164. 1 capital A is talking about this provision. Okay, for this. So here now the second option, the minister in every state holds office during the pleasure of the government. Yes, this is also correct. This is also correct. Now the third option, no person below the age of 21 years can be appointed as a minister. So we are here of the view that Article 173 is basically talking about that in order to be the member of the legislative assembly, you need to be of the age of 25 years. So this is basically the wrong option. So they are asking which of the options are right here. So we can go for B. B as a right answer in case of question number 10. Okay. Now coming on to question number 11. Let's see what question number 11 says. Question number 11 is basically talking about which of the following statement is not correct. So we have to find out कि statement कौन सा है जो correct नहीं है. We have to understand the question so that we should not commit any mistake. Okay, so first of all we have to understand the question. Now coming on to, a member of the State Public Service Commission holds office up to the age of 62 years. So if you refer the article 316, when you will go to article 316, you will find the provision that yes, the member of the State Public Service Commission is to hold the office for the age of 62 years, 6 years or at the max of 62 years. So there you will find this provision. Coming on to the second option, any member of the Public Service Commission can be removed from the office on the ground of misbehavior in the prescribed manner. Yes, this will be also there under Article 317. You will find that Article 317 you will find this provision. Yes, that on the ground of misbehavior, he can be, public servant can be removed. The member of the Public Service Commission can be removed. Now the third option, in the absence of the chairman of the Union Public Service Commission, the senior most member of the commission perform the duties of a chairman. So here I beg to differ. If you refer 316, if you refer Article 316 1A, you will find the provision that any other member is written and not the senior most member. Okay, so you have to check through the bare act that it is any other member of the commission. One of the any other member of the commission can be appointed to perform the duty of a chairman. So this is basically not the right option, and they are asking about the which of the statement is not correct. So here C is not correct. We can see D also, the chairman of the Union Public Service Commission is not eligible for any appointment with any government. Yes, this is also the right option. They are not eligible. So this is about the question number 11. Now we are coming to the question number 12, and before that I am always saying this, that you have to jot down the article numbers or the section numbers, so that you can refer those articles or sections in the bare act for future reference. Okay, now coming on to question number 12, which is talking about in which of the following states, they are talking about the states कि किस state में it is mandatory to appoint a minister in charge of the tribal welfare with additional charge of welfare of the scheduled caste and the scheduled tribe. तो कौन सा ऐसा स्टेट है जहां पे आपको मिनिस्टर इंचार्ज ऑफ द ट्राइबल वेलफेयर भी अपॉइंट करना पड़ता है अलॉन्ग विद द मिनिस्टर ऑफ शेड्यूल्ड कास्ट एंड शेड्यूल्ड ट्राइब, तो उसके पास एक एडिशनल चार्ज है। तो इसमें आपका ऑप्शन क्या हो सकता है, तो यू कैन स्ट्रेट अवे गो टू द ऑप्शन डी, दैट इज छत्तीसगढ़, झारखंड, मध्य प्रदेश एंड ओडिशा is basically here the right answer. And for this you can refer proviso to article 164. If you'll go to proviso to article 164, you will find the answer, or you will find the mentioning of these 4 states there. Okay, 164 clause 1 proviso. Now coming on to question number 13. So question number 13 is, there is no express provision for tribunals under which of the following provision of the Constitution of India. So we have to refer the bare act and we have to see कि भाई कौन से ऐसे आर्टिकल्स हैं जो कि ट्रिब्यूनल्स की बात करते हैं। दे आर आस्किंग कि इनमें से कौन सा ऐसा, देयर इज नो एक्सप्रेस प्रोविजन, कौन सा ऐसा प्रोविजन है जहां पे ट्रिब्यूनल की बात नहीं कही गई है। सो एज फार एज दिस इज कंसर्न, तो ट्रिब्यूनल्स फॉर एडमिनिस्ट्रेटिव पर्पस है हमारे पास 323A, वी हैव ट्रिब्यूनल्स फॉर पर्पस अदर देन एडमिनिस्ट्रेटिव पर्पस, that is 323B article. 371D is basically talking about the special provisions in the state of Andhra Pradesh and Telangana. Okay, so they are not talking about the tribunals. Now article 217 basically is talking about the appointment and the condition of the judges of the high court, so there also there is no discussion of the tribunal. Article 227 is talking about the power of superintendence of the high court, so again there is no discussion about the tribunal. So we can say that this is not the correct question, well framed, or the options are not given correctly. So just we can know about the articles and move ahead. Okay, there is no need to give or mark any of the answers here. Now coming on to article 40, question number 14. Under the Indian Penal Code, now the questions are of the IPC, and right now we have BNS which is enacted, and is coming into force from 2024. Okay, and you can give the date of enforcement in the comment, okay, of the BNS, BNSS and BSA. Now the corresponding provisions, I will try to give the corresponding provisions of the BNS also in the options. So under the Indian Penal Code, who among the following is not considered a public servant? So first of all we need to know that section 21 of the IPC is talking about the public servant. In that you will find that the members of the panchayat assisting a public servant is a public servant, is known as a public servant. So this is a correct option. You can go to the 5th point. An arbitrator is a public servant. You can go to the 6th point. Every person paid commission for the performance of any public duty, again this is also a public servant. You can go to the section 21 clause 12A, you can find there 12A. Okay, under the definition of public servant, this is also mentioned. An employee of the government company, this is also in 12B. So you will find that all are public servant, but if you will specifically go to the 6th clause, you will find that an arbitrator is a public servant only if it is appointed by the court. They have specifically mentioned that an arbitrator only if appointed by the court will be regarded as a public servant. So here he is not a public servant. As per the demand of the question, they have asked who is not a public servant. So option B is correct here. Okay, an arbitrator is not a public servant unless and until he is appointed by the consent or the approval of the court. Now moving ahead with question number 15. Question number 15 is talking about considering the following statement. The word government company has been used. This is a question of IPC. The word government company has been used but not defined under the Indian Penal Code. Yes, this is correct. IPC वर्ड सॉरी इंडियन पिनल कोड में गवर्नमेंट कंपनी यूज तो हुआ है कई जगहों पे बट कहीं पे भी डिफाइंड नहीं है. सेकंड ऑप्शन, द वर्ड मूवेबल प्रॉपर्टी हैज बीन यूज बट नॉट डिफाइंड अंडर द इंडियन पिनल कोड. आई बेग टू डिफर. अगर हम सेक्शन 22 रिफर करेंगे तो हमें पता चलेगा कि वहां पे उन्होंने मूवेबल प्रॉपर्टी को डिफाइंड भी किया है आईपीसी में. ठीक है. हाँ, पब्लिक सर्वेंट मैंने बोला था आईपीसी का सेक्शन 21 है. उसी तरह आप जब जाओगे बीएनएस में तो आपको वहां पे 2 का 28 2 क्लॉज 28 ऑफ द बीएनएस इज बेसिकली टॉकिंग अबाउट द डेफिनेशन ऑफ पब्लिक सर्वेंट. 228 of the BNS. Please do mention this. Here section 22 is basically talking also about the public servant. The same is under 221 of the BNS. Public servant, the definition of movable property here is under the provision of BNS, now 221 of the BNS and it was 22 of the IPC. Please do mention. तो ये defined भी है word और ये वर्ड जो है इन्होंने बोला है कि यूज किया है बट डिफाइंड नहीं है, तो ये गलत स्टेटमेंट है. यूज भी किया है और डिफाइंड भी है. नाउ अगेन ऑप्शन 3, द वर्ड इलेक्ट्रॉनिक रिकॉर्ड हैज बीन यूज्ड एज वेल एज डिफाइंड. यस, यूज भी किया गया है और डिफाइंड भी है, दोनों ही चीजें हैं. वी कैन रिफर 29A कैपिटल A ऑफ द IPC. वी विल फाइंड दैट इट इज देयर. ओके. तो इन्होंने पूछा है हमसे considering the following statement, which of the following statement given above is correct. So option 1 and option 3 is correct. So we'll go on to mark option 1 and option 3 is correct. तो अब हम इसमें क्या करें, इन्होंने ऑप्शंस तो दिए नहीं है तो हम क्या कर सकते हैं. पहला करेक्ट है और तीसरा करेक्ट है, तो इन्होंने पूछ लिया है कि क्या करेक्ट नहीं है. अगर पूछा जाए तो हम बोल सकते हैं कि भाई ओनली 2 इज नॉट करेक्ट. ठीक है. तो फिलहाल आपको इसमें ऑप्शंस पता चल गए हैं कि इन्होंने पूछा है. अब ऑप्शंस हमारे पास नहीं है आंसर में, सो नो इश्यूज, वी कैन मूव अहेड एंड वी आर अवेयर ऑफ द आंसर, दैट्स इट. ओके. फिर आगे बढ़ते हैं. क्वेश्चन नंबर 16 पे आते हैं. क्वेश्चन नंबर 16 इज बेसिकली टॉकिंग हाउ मेनी काइंड्स ऑफ पनिशमेंट हैव बीन प्रोवाइडेड अंडर द इंडियन पीनल कोड. तो अगर आप प्रिफर करें सेक्शन 53 ऑफ द आईपीसी, यू विल फाइंड दैट आईपीसी में जो ओवरऑल 5 पनिशमेंट्स हैं, 5 काइंड्स ऑफ पनिशमेंट्स हैं. ठीक है. और इसी का करस्पॉन्डिंग आप सेक्शन 4 भी ले सकते हैं बीएनएस में, विच इज बेसिकली टॉकिंग अबाउट द पनिशमेंट क्लॉज ओनली. ठीक है. तो उसमें बेसिकली अब जो है हमारे पास 4 की जगह 5 की जगह 6 पनिशमेंट हो गई हैं. बट अभी फिलहाल इसके लिए एज फार एज सेक्शन 53 इज कंसर्न ऑफ द आईपीसी, वी हैव 5 पनिशमेंट. ठीक है. उसमें एक पनिशमेंट ऐड हो चुकी है, दैट इज कम्युनिटी सर्विस. वो आप अपनी नॉलेज के लिए याद कर सकते हैं. तो इन्होंने पूछा हाउ मेनी काइंड्स ऑफ पनिशमेंट, सो द आंसर इज डी, दैट इज देयर आर 5 पनिशमेंट्स. मूविंग अहेड, क्वेश्चन नंबर 17 देखते हैं. Which of the following causes of death of a person do not amount to an offense. डेथ हुई है बट वो ऑफेंस नहीं कंसिडर किया जाएगा. ठीक है. देखते हैं क्या ऑप्शन हो सकते हैं हमारे पास. सबसे पहला है एन एक्ट कॉजिंग डेथ ऑफ अ पर्सन बाय एन इंटॉक्सिकेटेड पर्सन. तो डेथ कॉज बाय अ इंटॉक्सिकेटेड पर्सन इज एन ऑफेंस. तो इसको तो हम चॉक आउट कर देते हैं कि नहीं ये ऑफेंस है. अब चाहें तो सेक्शन 85 और 86 ऑफ द आईपीसी आप देख सकते हैं, तो वहां पे वॉलंटरी और इनवॉलंटरी इंटॉक्सिकेशन की बात की गई है. और करस्पॉन्डिंग इसमें आप 23 और 24 देख सकते हैं बीएनएस के, विच इज ऑल्सो टॉकिंग अबाउट द सेम थिंग. ओके. तो ये एक ऑफेंस है, तो दिस इज डज नॉट अमाउंट टू ऑफेंस, तो दिस इज एन ऑफेंस. आगे, एन एक्ट कॉजिंग डेथ ऑफ अ पर्सन बाय समवन हु हैज कॉज्ड अनइंटेंशनली एंड डिड द एक्ट विद द कंसेंट ऑफ द पर्सन हुज डेथ वाज कॉज्ड. तो अगर आप सेक्शन 300 देखें तो वहां पे आपको एक्सेप्शन 5 में ये सिचुएशन मिल सकती है. नाउ इट इज 101. ठीक है. तो ये भी हमारा ऑप्शन है कि भाई दिस इज एन ऑफेंस, तो ये भी नहीं फॉल करेगा. थर्ड देखते हैं हम, एन एक्ट डन इन गुड फेथ फॉर द बेनिफिट ऑफ अ पर्सन हु डेथ वाज कॉज्ड unintentionally without his consent as he was not in position to give his consent. Yes, this is basically not an offense. ये आप सेक्शन 88 में देख सकते हैं कि दिस इज नॉट एन ऑफेंस. सेक्शन 88 ऑफ द आईपीसी इज टॉकिंग अबाउट दिस. करस्पॉन्डिंग आप इसका सेक्शन 26 ले सकते हैं बीएनएस का, विच इज ऑल्सो टॉकिंग अबाउट द सेम थिंग. नाउ इट इज सेक्शन 26. तो बेसिकली इनके जो क्वेश्चन है उस हिसाब से हमारा जो थर्ड ऑप्शन है वही करेक्ट है. तो द आंसर इज डी. Now, question number 18. Question number 18 is basically talking about under which of the following situation a person can be punished with imprisonment extended up to 5 years. तो ये जितने भी provisions हैं you will find under section 153B. Section 153B of the IPC जो कि religious ceremony और उन सब की बात करता है, और इसका corresponding section 197 BNS हो सकता है, उसको भी एक बार आप देख लीजिएगा. तो when you will go to the 153B of the IPC you will find that वहाँ पे ये mentioned है कि makes an imputation during the performance of a religious ceremony that any class of persons on account of their religion cannot bear true faith and allegiance to the Constitution of India. तो आप जब जाओगे तो आप देखोगे कि यहाँ पे जो सजा दी है जो उन्होंने दी है वो थी है up to 3 years, can be extended up to 3 years. तो क्लॉज 1 में जो पनिशमेंट है वो 3 ईयर है. क्लॉज 2 इज टॉकिंग अबाउट प्रोपोगेट ड्यूरिंग अ पंचायत मीटिंग. तो एक एसोसिएशन है लोगों का, कई लोगों का, उस समय अगर यही चीज करते हैं आप, कुछ ऐसा बोलते हैं, तो वहां पे भी 3 ईयर ही पनिशमेंट है. नाउ कमिंग ऑन टू क्लॉज सी विच इज अगेन टॉकिंग अबाउट द सेम थिंग कि अपील ड्यूरिंग एन इलेक्शन कैंपेन concerning the obligation of a class of a person belonging to any particular religion to cause feeling of enmity. तो अगेन यहाँ पे भी पनिशमेंट 3 ईयर्स ही है. मैंने बोला ना आप पूरा का पूरा 153 क्लॉज बी देख लेंगे, आप 153 कैपिटल बी देख लेंगे, आपको सारे के सारे क्लॉजेस सेम एज इट इज मिल जाएंगे वहां पे. बट एक चीज आप बस नोटिस करेंगे, जो क्लॉज डी है आपका, ये जो सिचुएशन है दैट इज अंडर 153 कैपिटल बी क्लॉज 2. यहाँ पे जो आपकी पनिशमेंट है, here the punishment is 5 years. So the option that is correct is D in this particular case. Now again moving to question number 19. Question number 19 is talking about selling, distributing or circulating in any manner any obscene book, paper, pamphlet in any offense punishable with imprisonment except in which of the following cases. तो इन्होंने बोला है कि इसमें से कौन सा ऑफेंस नहीं होगा या कौन सी चीज नहीं डिफाइंड है. ठीक है, तो आप जब आईपीसी में जाओगे तो आप देखोगे वहां पे 292 है, सेक्शन 292, और उसका करस्पॉन्डिंग है 294 ऑफ दी बीएनएस. यू विल फाइंड द सेम प्रोविजन, और वहां पे ये चीज स्पेसिफिकली डिफाइंड है दैट एनी रिप्रेजेंटेशन, अगर आप क्लॉज बी में जाओगे, बी के 1 में, तो वहां पे स्पेसिफिकली ये डिफाइंड है, बताया है, एनी रिप्रेजेंटेशन एनग्रेव्ड इन एनी एंशिएंट मॉन्यूमेंट वेदर और नॉट कवर्ड अंडर द एक्ट. ठीक है, तो वहां पे इन्होंने एंशिएंट मॉन्यूमेंट वाली बात की गई है, तो वो आप एक प्रोविजन देख लीजिएगा, करस्पॉन्डिंग बीएनएस का देख लीजिएगा 294. so this is a correct option. Now the second option is also mentioned any obscene book, pamphlet, paper kept bona fide for religious purpose. वहां पे ये लाइन आपको मिलेगी, that is A का 2 ऑफ द 292. ये प्रोविजन भी आप देख लीजिएगा, तो वहां पे आपको ये चीज मिल जाएगी. Okay, so both the points are right here, so the correct option is that both are correct, so C is the correct option. Now coming on to the last question of the day, and tomorrow again we will be having the session, and in that session also we have 20 questions which will be of Indian Evidence Act, also comprising of CRPC and other subjects as per the syllabus of the CBI, APP and PP. Now coming on to question number 20. This is the last question. Considering the following statement with regard to causing grievous hurt by use of acid. So here section 326, section 326 capital A of the IPC is talking about death caused by or throwing of acid, the crime of throwing the acid, the act of administering the acid. Okay, So here the corresponding provision is 124 of the BNS, which is also talking about the same thing. They are asking about कि इस स्टेटमेंट को अगर आप कंसिडर करते हो तो ग्रीवियस हर्ट बाय यूज ऑफ एसिड किस में फॉल करता है? तो वॉलंटरी कॉजिंग पार्शियल डिफॉर्मिटी इवन ऑफ द रिवर्सिबल नेचर मे बी पनिश्ड विद द सेंटेंस ऑफ इम्प्रिजनमेंट। हमको एक्चुअली इसमें करेक्ट सेंटेंस फाइंड करना है अकॉर्डिंग टू द डेफिनेशन और द प्रोविजन गिवन अंडर सेक्शन 326 कैपिटल ए। तो सबसे पहला पोर्शन जो है यू विल फाइंड अंडर सेक्शन 326 कैपिटल ए, बट एक चीज है वहां पे सेंटेंस ऑफ इम्प्रिजनमेंट जो है वो मैक्सिमम है और वहां पे लिखा है अप टू फ्रॉम 10 ईयर्स टू 10 साल से लेके। तो 10 ईयर्स का वहां पे उन्होंने एक प्रोविजन दिया है, तो वी कैन नॉट से कि स्ट्रेट अवे इम्प्रिजनमेंट फॉर लाइफ ही होगा, नॉट लेस देन 10 ईयर्स होगा और मे एक्सटेंड अप टू द इम्प्रिजनमेंट फॉर लाइफ। एक ये यहाँ पे ऐड करना है। दूसरा, द ऑफेंडर इन द केस ऑफ ग्रीवियस हर्ट कॉज्ड बाय एसिड may be imposed fine which has to be just and reasonable to meet the expenses of the treatment of the victim. So ये एकदम सही है and this you will find under the proviso to this section. So again this is a correct answer. Here there is a addition that is 10 years, not less than 10 years. So here अगर हमसे पूछा जाए कि इनमें से कौन सा स्टेटमेंट सही है या कौन सा गलत है, तो सेकंड वाला सही है। ठीक है, तो ऑप्शन 2 और ऑप्शन बी इज द राइट आंसर। So here this is all about this discussion on the CBI paper. Tomorrow again we will have the same session by 3 in the afternoon. Hope you all will be there and we'll solve again the set of 20 questions. This all will be, we'll be having a 6 sessions of 20 questions. The entire CBI paper, basically this entire CBI paper will be consist of 120 questions which are divided into 6 parts, and this is a paper of 300 marks and there is a negative marking. So if you are scoring suppose 100 marks and there are 5 questions wrong, so 1/3 of whatever is the mark that particular question carries, 1/3 will be a negative marking. And the syllabus is detailedly discussed in the previous videos, so you can go there and have this and can listen about the eligibility and the syllabus thing. Okay, thank you very much for the session.